Boom. Hey, folks. How's everyone doing? I hope everyone's having a wonderful morning. We're probably going to do this video, or not this video, but we're going to do this issue twice. That's a bit of an experiment because there's folks who are right now at work and who are probably going, yeah, I could use something to make my day suck a little less because, work can suck. And there's folks um, who are probably, overseas and so forth, and would like to catch a live. So yes, we've got somebody from Stockholm, Sweden. Probably, I'm trying to mix up the times where I can to allow for some people to tune in who might otherwise not be able to. Kurum Alligator says, "How dare you call me out at my desk on my lunch break? That is fair." All right. And having COVID also sucks. So I guess you're homesick and just going, yeah, this is not fun. Can I make Microsoft Teams suck less? I do not have that power. And if I did, I would probably be using that level of ability to stop floods and, so forth. So yeah. I hope everyone is having a wonderful day. I hope everyone is, I hope things are going pretty well. I cannot say I slept well. I had a wonderful dream. I had everyone's favorite dream. This is actually my least favorite dream. Let me tell you about the dream. So this was a recurring dream, so it would keep coming up every time I went back to bed. And the dream goes like this. Sound of my alarm clock. I don't know why my brain thinks that's funny. Like, my brain is like, hey, you know what? I bet I know how I can really, really troll this guy. And that is by dreaming of his alarm clock. So, yeah. And then the dream of my alarm clock wakes me up and I look over at the clock and it's like, oh, it's 4 a.m. That is not an appropriate time to be woken up. So fun. I'm just going to say that is a brilliant bit of trolling, but yeah. All right. Somebody says, how was date night with Mrs. Runkle? Date night was great. We went to a place called the Captain's Boil, which I know sounds delightful, but they boil seafood in sauces, and it was excellent, and there was way more food than either of us could eat in a sitting, so I've probably got some lunch, unless Mrs. Runkle took it with her to work, in which case I don't have lunch. Did I wake up Mrs. Runkle? No, she was still, at least not to my knowledge. Yes, the crustacean in your Caesar made me gag. They serve a Caesar that comes with an entire crayfish in it, which is lovely to me. Okay, so today we are going to be going over Hannah Gutierrez Reed's lawyer has filed a new motion for a new trial. And you might be saying, oh, who could have predicted this? Well, I predicted it, but I'm not going to toot my own horn too much on this because that was a little bit like predicting that like Hannah's lawyer would file for a new trial was like predicting, predicting that a lottery winner might quit his job or that kind of thing. Right. So, yeah. All right, so let us have a look at the entirely predictable motion, as well as the less predictable things in it, because there's some spice in it. There's some allegations made. There's some issues in this one, and for some reason, it doesn't want me to show you that screen. Why is it not? Okay, so StreamYard is being annoying. Give me 1 second while I wrangle around StreamYard. while I wrangle around StreamYard here. We're going to work around it. We're not going to let StreamYard slow us down too badly. So, I'm just going to do this, present, share screen. Is it this one? It is this one. Okay, cool. We've got a screen. And I'm going to smallify myself, and I'm going to bigify this. Those are all like terms of art. So there we go. Hannah Gutierrez reads expedited motion for new trial or for dismissal for discovery violations and under the court's inherent power. Okay, so what does that mean? It means that they are asking for a new trial. Now, this was filed twice on their thing, and I suspect that the reason why it was filed twice was they actually had to ask the court. They were like, "Court, listen, I know that we're only allowed 10 pages for these. We're only allowed 10 pages, but we need more pages. We need all the pages. We need so many pages." And so they say we need like 32 pages. And the court's like, you know what? We're going to grant that. File all the pages you need to file. And here we go. So now there's some things in this that I 100% expected. And there's some things in this that I was like, oh, okay. Now we're getting into some fun things. And I'm going to say I've been seeing some people online who've been commenting about what's happening in this motion who clearly didn't read the motion. So defendant Hannah Gutierrez Reed, by and through her counsel of record, Jason Bowles and Monica L. Barreras, I'd forgotten she exists, but she does, respectfully moves this court for a new trial or for dismissal for severe and ongoing discovery violations by the state. So basically the same thing, right? This is the same thing to say we want to allow, we want to say, hey, we haven't gotten all of this information that the government was supposed to give us. But now I just want you to stop, and we're just going to soak in for a second this top heading right here. We're just going to stop and soak this in for a second. Baldwin's trial exposes extreme misconduct. Special Prosecutor Morrissey lies to this court under oath. That is a hell of an allegation, but you know what? I think he's going to be fine on this one, because I think the court kind of thought that she kind of didn't believe everything that she had to say. So let's see. Some of his claims here are maybe a bit of a stretch for alleging perjury, but some of the claims here, I think he has a much better leg to stand on. So in the hearing on July 12th, 2024, in Mr. Baldwin's case, Ms. Morrissey took the stand, calling herself as a witness, which was insane, by the way, and lied to this court several times. Corporal Hancock testified that Ms. Morrissey was in on the decision to file the Teskey rounds in a separate file. On direct examination, Ms. Morrissey stated that she never knew it would have a separate file number. Okay, I don't know that that gets us to lying under oath here, right, for this specific part, because we could also conclude that Corporal Hancock was wrong, right? That's another possibility. However, they go on, Ms. Morrissey alleged in response to cross-examination that Erlinda Johnson had resigned that day because Ms. Johnson didn't want a public hearing on the Brady violations. This was false. In a media interview the same day, Ms. Johnson explained that she resigned because of her ethical duties as a prosecutor, and that she had argued that the case should be dismissed by the state because of the late disclosure, and that she was overruled, obviously, by Ms. Morrissey. Now, a couple of problems here. One, do you have an affidavit from Ms. Johnson, or are you just relying on her media interview? Because you should really have an affidavit here. The second thing is that I don't know that these are necessarily inconsistent, because when you say that she didn't want a public hearing, well, argued that the state should be dismissed by the state, would also have prevented the public hearing. So, still not to perjury here, sir. At least I'm not. But he's going to go on. He's going to go on. So, see, Baldwin, prosecutor on resigning. Erlinda Johnson interview with Chris Cuomo, available on X, brackets Twitter. I love how that rebranding is going, because everyone is like, available on X, which is Twitter. Like, just so you know what we're talking about, it's Twitter. Ms. Morrissey instead decided to plow ahead in her continued win-at-all-costs attitude in the Rust cases. Now they're going to get a little better here. Second, Ms. Morrissey represented in response to questioning that she asked her prior paralegal to resign. That was factually untrue. The paralegal decided to tender his resignation unilaterally after sending several emails to the DA's office about his working conditions and the conduct of Ms. Morrissey that led to his unilateral decision to resign. Now, here's where you get to, oh, he's actually bringing some better ammo. The paralegal emailed this to undersigned counsel and executed an affidavit. This is key. They do have an affidavit, apparently, from this paralegal. That is a big thing. Why she went under oath to testify about this is just bizarre. However, this is an excellent point. Literally something I don't care about. Why'd the paralegal quit? It is a big deal if she lied under oath. But you're right. This is a side issue, especially if she lied under oath in a separate thing. But yeah, people walking off prosecution, like the cameraman walking off Rust, kinda, yep. There's a witchcraft-related trial. I have not heard about it, but I will try to take a note. I'm just going to, where can I take a note? Pulling up a notepad. Yeah. Tyler Daisy, you said. Okay. Tyler Daisy. I'll look into that later. All right. Third, Morrissey represented that undersigned counsel did not want the Teskey rounds and believed they inculpated Ms. Gutierrez-Reed. So he's saying they said stuff about me, too, in that. That is an absolute falsehood. Some background is necessary on this point. The state had been aware and had access to Teskey for years. Seth Kenney called Teskey during a November 1st, 2021 interview with then-Detective Alexandria Hancock, after which Teskey sent a picture of a sampling of ammunition, and the sampling had bronze primers and didn't match the live rounds on set, which had nickel primers. There was no further follow-up by the state, even though undersigned counsel texted Detective Hancock asking her to contact Teskey. Detective Hancock also misrepresented at the hearing, saying she'd called Teskey multiple times with no response. Detective Hancock's testimony was extremely suspicious. I had some concerns about that. Hancock, in text responses, told undersigned counsel that she'd already talked with Teskey. Yes, I've been present for most of the phone calls and have spoken to him, and also saying I'm aware, I've seen them, and spoke to Troy. Hancock never again tried to contact him, despite her testimony to this court. Okay, so that's so far about Hancock. Now, then in a November 2nd, 2023 pretrial interview of Teskey, the rounds were again discussed, this time with Special Prosecutor Morrissey. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had taken to the 1883 set. Teskey agreed he would preserve it and provide it, and Morrissey indicated he should, and that she would work with law enforcement to collect it. Thereafter, Teskey was afraid to do anything with the rounds, except preserve them for law enforcement, which he did. So, why does Baldwin get dismissed with prejudice, but Reed is only asking for a retrial? We'll get to that. But I just wanted to note that I did see this, so we will get to this. We'll get to this. So Morrissey never followed up. The undersigned sent an email to Morrissey on January 8th, 2024, asking if the state was going to retrieve the rounds and test them. Counsel stated in the email that testing was important to compare the powder of the Teskey rounds to the powder in the live rounds found on the rust set. This had to be done by the FBI through the state, as the FBI had done the original testing and analyzed the powder. Undersigned counsel had repeatedly told the state that it needed to test the Teskey rounds and make this comparison. That same day, however, for the first time since November 2nd, Ms. Morrissey emailed back that she did not plan to retrieve or test them because she found them visually dissimilar and not relevant. Here's the thing, though. He says that it had to be done by the FBI. I am going to strongly disagree with him, because that kind of testing as to, like, this ammunition could actually have been done by basically anybody with some experience and a microscope. So I'm just going to note that given the photos from the FBI, given those, I could absolutely have done the testing myself. Now, I'm not the guy you'd want for the testing. You'd want an actual expert. But I could have actually done the comparison. And the way you would have done the comparison is you just send a private investigator to pick up the ammunition. You take it to your gun expert. Your gun expert uses a bullet puller to pull that bullet, and then can then go and have a look around at it. Somebody's saying order of recusal on file. Is there a new order in this case? Okay. I'm going to see if there's a new order that's been posted. So nothing has been posted in this case yet. So yeah, you would just you would use a bullet puller to pull the bullet. You would look at the powder, and young thug. Yes, I did see that. That's that we're not talking about. So guys, let's keep to the case that we're talking about, because you are distracting me and it's not good. So you could pull the bullet, you could look at the powder, you could see that it's the same shape, the same size, right? And then that will tell you what kind of powder it is. And you'd be like, oh, it's the same, because powder comes in different sizes and different shapes. And the reason why it comes in different shapes, and you're not going to be able to see these shapes with your naked eye. These are very, very small. To the naked eye, it's just going to look like granulated powder. But under a microscope, you will be able to see those different shapes. They might be spheres. They might be discs. They might be rods. They might be little hoops. And the reason why is that you get slightly different burn performance based on those shapes and the size of the powder. And so if you use different shapes, you may get different characteristics for how fast this powder burns. Why does that matter? Well, it matters a lot. And the reason why is you want a burn rate that is going to cause the projectile to fly out in the right way, whereas you don't want one that's going to either burn too slowly, and therefore you're not going to have enough oomph to make things happen, or burn too fast. Because if it burns too fast, then you might pull the trigger and the gun goes boom in your hand. You don't want that. You don't want the boom to happen in your hand, and that's not a good thing. It can actually literally potentially kill you. So this, but when he says that this had to be done by the FBI, no, they could have done their own comparison. And I'm sure that they could have said, our expert needs a sample of the powder to test it, right? We need a sample. We need to do, chemical examination. We need to do physical examination. And the other thing is that they could have gone and done the physical examination, even if they didn't have access to, a chemist to do like grass chromatography and so forth. They could still have just looked at it physically and said, they call their expert to say it's a physical match. And then they say, and you guys, like when the government experts get up, they're like, you guys never tested this, right? That would have been a big thing. Okay. So that same day, however, for the first time since November 2nd, Ms. Morrissey emailed back that she did not plan to retrieve or test them because she found them visually dissimilar and not relevant. Astoundingly, Ms. Morrissey told this court in the July 12th hearing that she'd never seen these rounds until July 12th during the evidentiary hearing. It was clear in that hearing that 3 of the rounds were visually like the rust set rounds, which contradicted Ms. Morrissey's in-court statements from July 11th that the rounds were not visually similar. And I think she was surprised by that. See also a Erlinda Johnson interview noting that 3 of the Teskey rounds were visually like the rust set rounds and indicated that this had potential exculpatory value on the theory of sabotage. Note as well that I don't think Erlinda Johnson knew that either before the 11th or the 12th. I don't think she knew that either until those were brought out in court. Further misconduct by the state unearthed in that hearing was that CST Popple had been directed to place the Teskey rounds in a separate case file with a separate number, not rust, and create a report that was also filed in that separate case file, so these would not be disclosed to the defense. Corporal Hancock testified that Ms. Morrissey was present for the meeting and the decision to place the rounds in a separate case file. Ms. Morrissey denied that, though. Ms. Morrissey denied that. In other words, Special Prosecutor Morrissey was in on the decision to hide the rounds and report on them in another file. Moreover, Constable Popple and Morrissey misled this jury in testimony on July 11th, 2024, indicating that the Teskey rounds were visually dissimilar to the rust set rounds and therefore immaterial. That was proven false a day later when this court opened the box and inspected the Teskey rounds, which turns out to be the case, right? That was false. Far from distancing from the Teskey rounds, defense counsel recognized their potential exculpatory value had the state tested them. However, by the time Ms. Morrissey indicated that she did not plan to... Now, this is dumb to me, because if you thought they had exculpatory value, why wouldn't you run this in court? Why wouldn't you argue this issue in the trial and say, weren't there some additional rounds found? Isn't it true you never tested those? I find this bizarre, because if I thought that there were additional rounds, I would have argued the hell out of the Teskey issue at Hannah's trial if I thought that could have indicated something like sabotage. But we're going to get a little bit to my thoughts on the sabotage theory as well. So, and guys, there are 2,000 of you in the chat. Please hit the like button if you're enjoying this, if you want to see more of this. Also, super chats are always welcome, but hit the like button, share it with your friends. Those kinds of things really helps. I know times are tough, so I don't want to encourage people like super chat, because people don't have any money these days, and it sucks. It's we're all kind of struggling along. I'm doing all right, but I see tent cities getting bigger and so forth. It's messed up. So, however, by the time Ms. Morrissey indicated that she did not plan to retrieve them on January 8th, it was too late to utilize these rounds and impossible without the FBI comparison on the powders. How is it impossible? How is it impossible? Because you could absolutely say, aren't these rounds there? Did you go get them? Did you test? You could absolutely ask these questions and argue these issues without that. And I got to interrupt things for just a second. Suitors says, hi, Runkle. We've been watching you since your channel started. Can you shout out to my friend Wendy, currently in Hong Kong, also watching you? Hello, Wendy. It's good to have you watching. Thanks. Love your work. Cash for your pro bono fund. Thank you so much. I am very much hoping that the pro bono dream can be a thing. So let's try to make that happen. So this court had also made clear in one of the motion hearings around that time that there would be no continuance of the February 28th trial date for Ms. Morrissey. Did you say I need a continuance because there is ammunition that from Mr. Teskey that hasn't been tested? Did you actually say that? Because if you didn't say that, then no kidding, the court wasn't going to grant your continuance. But you should have said we need a continuance because there is ammunition that is out there, right? So, yeah, that would have been a good reason for it. Dally Talk says, I got a huge portion of the discovery. If you want to send anything my way, I'd be happy to see it. It is shocking how bad Bowles was. Oh, we saw that in the trial. Also, Seth Kenney is seriously suspicious. That is fair. I'm going to talk about the sabotage via Seth theory and what it means. So we'll talk about that at the end. We'll talk about that towards the end here. So regardless, without the state testing the rounds, counsel for the defense was unable to utilize the power for comparison. You could certainly argue that they never tested that. Teskey then turned the rounds over to the sheriff's office on March 6, 2024, and you could have actually done your own testing. So, and the defense hoped that the sheriff's office would finally test and analyze those rounds while Ms. Gutierrez-Reed pursued her appeal. Instead, the state placed them in a separate case file and attempted to hide them. Erlinda Johnson recognized the import of the rounds, as she stated in her interview, as soon as she saw the 3 silver primer Starline brass rounds on July 12th when the court took the rounds out of the evidence box. And I suspect that's also when Morrissey recognized their importance. I just think they had a different approach as to what they were doing. So Ms. Johnson indicated that it made the theory of sabotage a possible defense theory and defense assertions that Ms. Gutierrez-Reed was a wonderful armorer. She was not a wonderful armorer. She was not a wonderful armorer at all. This goes to the foreseeability element for Ms. Gutierrez-Reed as well, and could have been more exculpatory in Ms. Gutierrez-Reed's case. We're going to talk about was she a wonderful armorer? The import is that Ms. Morrissey and Constable Popple made misrepresentations to the court and jury regarding the Teskey rounds and the circumstances surrounding their late disclosure. These misrepresentations highlight the continued discovery, abuses, and fraud perpetrated and attempted to be perpetrated on counsel for the defense and this court by the state. Counsel for Ms. Gutierrez-Reed knew that Teskey had some rounds from the same batch and is not making that failure of disclosure the sole basis for that motion, except to the extent that they show ongoing misconduct of the state and the failures found by the court. So they knew that Teskey had some rounds for the same batch. Okay. Oh, yes, crime scene tech, not constable. I keep thinking constable. Crime scene tech. Thank you. So my brain is just doing weird things because I did not sleep all that well. So although counsel for Ms. Gutierrez-Reed was also never provided with a copy of the police report or lapel video concerning those collected rounds. That's a better argument. These additional acts by the special prosecutor should inform, however, the egregious Brady violation regarding the Haag report and the Giglio violation regarding the Seth Kenney interview that was disclosed only after trial. Okay, so these are, why are you burying this? I would have put those things front and center. This court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. How can it be any different with Ms. Gutierrez-Reed's case with this proven litany of serious discovery abuses? The intentional withholding of crucial evidence, Brady and Giglio, by the state has compromised the integrity of the entire judicial process. Justice demands that Hannah Gutierrez-Reed's conviction be overturned immediately, ensuring that the legal system does not perpetuate this core affront to our system that has been watched all over the world. Okay, and Joey Jones Donnelly says, I was saving this for your pro bono fund for the second week of trial, but, well, thank you so much, Joey Jones Donnelly. Much appreciated. That and somebody saying, I don't like boiled seafood in a bag. It's a big thing in Florida. It's tasty. It was tasty. So, introduction and factual background. At a stunning evidentiary hearing on Friday, July 12th, 2024, in Mr. Baldwin's trial, this court found that the state, I will agree that it was stunning. I would not, normally I would criticize Bowles for the overwrought language about stunning. I'm not a big fan of overwrought language in filings I tend to play things a little, I tend to be like, let the court get to stunning. I will just, I'll tell the court what's going on and the court can determine stunning for themselves rather than me trying to tell them. Because if the court doesn't agree with it when you say stunning, then the court is rolling their eyes. Here, I actually think stunning. Yeah, I'm gonna give him that one. It was. So Bowles, absolutely. This court found that the state had committed an egregious discovery violation by suppressing material Brady evidence regarding the ammunition rounds that Troy Teske turned into the Santa Fe County Sheriff's Office on March 6, 2024. This court entered the extreme remedy of dismissal with prejudice in Mr. Baldwin's case, finding, 1, the special prosecutor and sheriff's office suppressed evidence of the rounds that Mr. Teske turned in. 2, the evidence was favorable to Mr. Baldwin as impeachment evidence and potentially exculpatory. 3, the evidence was material in that the late disclosure impacted the fundamental fairness of the proceeding. 4, the state's conduct was highly culpable in failing to provide this discovery and unilaterally withholding a report on the Teske rounds. 5, the state's willfulness was so close to bad faith as to show signs of scorching. Lots of people quoted that because it's a very, very quotable line. They're basically saying if the bad faith is a fire, you're so close to it that it's burning you, even if it's not actually in there. This was highly prejudicial to Mr. Baldwin and his preparation for trial. The sanction of dismissal was the only appropriate remedy for the egregious conduct, and despite the state's repeated disclosures to defense in the court that they had complied with all their discovery obligations, they withheld critical evidence, and dismissal with prejudice was necessary to preserve the integrity of the judicial system. See YouTube. See moment judge throws out trial against Alec Baldwin, July. Why the fuck? Pardon my language. Why are they citing to the YouTube video? And this isn't like the YouTube video of the entire case court proceeding. They're citing to a YouTube video of an edit of this. Why wouldn't you just cite to the transcript? Why wouldn't you just cite to the actual case? And why is there no footnote here? Whose YouTube video is this? Do they, I'm just going to scroll down. Do they actually have, do they have the YouTube video cited here? Like, which YouTube video? Which YouTube video is it? So, I just, okay. Okay. Yeah, maybe they haven't got the transcript available yet, but the judge was there. And if you're going to cite to a YouTube video, maybe tell us which one it is. That's not an appropriate citation. That's a bad citation because I don't know which video that is. Maybe it's like a court TV thing. Maybe it's maybe it's some random guy who just decided to clip it. Maybe it's some edited thing. Maybe it's a Runkle video. I don't know. Yeah. I don't know. So this is, of course, the same special prosecutor and same sheriff's office that handled the Gutierrez-Reed case. In the same way as in Mr. Baldwin's case, the state represented to counsel and to this court that it had complied with its obligations under Rule 5501. Please see State Certificate of Compliance filed February 12, 2024. Yet, After the trial concluded, the state continued its pattern of discovery misconduct, disclosing a completely new interview of Seth Kenney and a third expert report of state's expert Lucian Haag. This is the bigger deal, right? He's running on the whole thing of, like, he's got a lot of arguments about the stuff that happened in the Rust trial, but this is the bigger issue for him, right? Because these are things that should have been disclosed. Because he has to admit at the end of it, he's like, I guess I did kind of know that those rounds existed. Whoops, my bad. So, yeah. So, on April 8th, 2024, a full month after Ms. Gutierrez-Reed's trial had ended, Ms. Morrissey called counsel for Ms. Gutierrez-Reed and disclosed an entirely new Seth Kenney interview and statement that contained numerous points that could have been used in Seth Kenney's cross-examination. Also, the state withheld bombshell exculpatory evidence that it had a constitutional obligation to disclose and that would have resulted in a fundamentally different trial and likely a different outcome. Okay, that's on April 8th, 2024. Chat. Can someone tell me what month is it now? What month is it now? Is it April right now? Is it May? Is it even June? No, we're in July. April is the 4th month of the year. July is the 7th month of the year. So you're saying that Ms. Morrissey disclosed this in April and that you sat on it for 3 months? That's a problem. That's a bit of an issue. So why are you sitting on it? Why are you sitting on it? So, as the court is aware from ongoing proceedings in Ms. Gutierrez-Reed's and Mr. Baldwin's case, despite having in its possession a report from its own experts stating that the firearm used on the set of the Rust contained unexplained tool marks on critical surfaces of the trigger and sear, which likely were not the result of damage incurred during the FBI's impact testing, and do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation, the state buried this information and never disclosed it to Ms. Gutierrez-Reed. But not only that, the state then called the expert at trial and sat idly by as he perjured himself during cross-examination. In doing so, the state, 1, suppressed exculpatory material in violation of the U.S. and Mexico constitutions, 2, suppressed a testifying witness's written statements in violation of Rule 5501A5, and 3, committed additional violations of the U.S. and New Mexico constitutions during trial. Okay. Okay. Now, April 8th, by the way, was after trial. After trial. But it was not actually after the matter was concluded, because that was actually still during sentencing. And so they could have brought that up at that time. They could have said, hey, we have an issue there. What's the issue? And Bowles, even after this, after he got this material, he files an appeal. And you know what his appeal is based off of? It's based off that shaky jury instruction thing that Bowles is wrong about. That he's wrong about. That he's incorrect about. So why... Like, sir, are you saying that you let Hannah Gutierrez-Reed get sentenced and you brought your appeal up and you were sitting on this? Because if so, you are an awful, awful lawyer, letting your client sit in custody when you've got a like this argument to approach or to advance. Bowles, I'm just going to say here, Bowles is saying, amongst other things, that we know that Ms. Morrissey lied because Bowles personally has evidence to say that she lied. Bowles should not be arguing this motion. Bowles should be getting off the record on this motion in order to let someone else argue it, because he needs to put in an affidavit. And he also needs another lawyer to seriously consider whether one of Hannah's grounds of appeal needs to be ineffective assistance of counsel. Because sitting on this Brady violation, that's starting to sound like we might be talking about some ineffective assistance. Now, I don't think they're actually going to find ineffective assistance of counsel. The test is so strict. But yeah, I just don't see it. So this conduct is beneath what the court should expect from a duly appointed officer of the state tasked with doing justice. These late disclosures occurring after trial had concluded violate Rule 501H, and there's a reasonable probability that the outcome of the trial may have been different had the state complied with its obligations. So they also have the suppressed Seth Kenney interview. In the Seth Kenney recorded interview, conducted well prior to trial of Ms. Gutierrez-Reed, there's no date contained in the interview, but it occurred before her trial. Mr. Kenney makes the following material statements that counsel for Ms. Gutierrez-Reed would have used in cross-examination. Okay. Yes, I would still say something nice to him because it's just the nice thing to do. I don't really feel a need to be a jerk to people if I don't have to. But yeah. So first, there's a standard that the prop master, Sarah Zachary, is the boss, and if something goes missing or stolen, she must report it. She is managing things, which allows the armor to focus on guns, and Sarah is everything else, i.e. everything else, not the guns. Okay. Hannah grew up on the set of movies and has a lot of immersion in set industry. She has more experience with Westerns than Seth did up until 1883. Okay. Says prop masters who handle guns won't call out armor to test bullets. Okay, that fine. Mentions that the sheriffs confused the replica gun with a real gun. Sarah told him Hannah was doing great things with the guns, and the director was happy. Seth heard nothing but good things about Hannah's skills. All the stuff that came out about safety he hadn't heard. He felt like people were piling on after the fact. Yeah, no kidding. That happens when somebody dies, right? People will say nice things about your work until, like, you cause somebody to die, right? Then people start getting... why is everyone getting so judgy after someone died? Why is everyone so judgy? I mean, they probably thought that she was the really cool armorer, letting them do all sorts of things and so forth, right up until it was like, oh, that was a bad idea. That was a bad idea. He mentions the anonymous hotline and that if there's something going on, why nobody called the hotline? Because nobody calls those things. Alex Hancock has been cool, but I busted her chops on the search warrant. Says he got 325 rounds from Thel Reed. Says Sabotage could be anyone on set. I mean, I think that they already did explore that. Literally anybody could have potentially thrown some rounds into her stuff because she didn't have any way of protecting her stuff from Sabotage. She just had open ammunition. She had open stuff, and literally, like, anybody who had some rounds in their pocket could have thrown them in there. That's not a point in her favor. 11, it's a boys' club. Alec Baldwin trusts AD because he's a man. If she said she got pushed around, no one would disagree. She's got the experience. If she ever came up with that kind of defense, then I'd think, well, finally, you're going to be real about this thing. Okay. Here's the thing. Her job is not to get pushed around. If the camera crew didn't feel safe, well, then call the hotline. They say, it's kind of suspicious to me. If they got their hotels, would they have said they didn't feel safe? He talks about Sarah's accidental discharge. Sarah was super responsible and apologized to everyone. That is not super responsible. Hannah was trying to punch down on Sarah for accidental as discharge. Accidental discharges happen. Mentions Tim McGraw, Daniel Craig, and Denzel Washington having them. He told Hannah to let it go about Sarah's accidental discharge. As to Hannah, he says, Alec, AD, and Baldwin, how are you not making sure a 25-year-old armorer has every ounce of support? She's an armorer. That's her job. She's got the experience and the history. She's had more set time on Westerns than I did before 1883. Sarah was collateral damage. He told her he would find her an adult armorer. I mean, she's 24 years old. That's an adult. Like, she is able to vote. She's able to go to the military. She's able to drink. She's able to consent in other ways. She's able to everything, right? At 24, you're absolutely an adult. And yeah. So Hannah came out strong. She was pushed around by Baldwin and AD. Props department needs every ounce of support. Says Sabotage, the Sabotage theory, is bullshit. Well, I agree with that. Several of these statements are new and different and would have been critical to cross-examination of Mr. Kenney. I agree with this. I agree that having this statement is absolutely critical, because anything that is even slightly different, you want to use on cross. One of the things so I'll have clients who will, occasionally you get a client who goes in and they say, hey, listen, I want to, now people are saying everything but rent a car. That's a, like, up to the car rental thing. That's not like a government power. So like, the car rental place is allowed to renter the car. They just don't want to. And the reason why is because 20-somethings do stupid things in rental cars. So, all right. So, but the thing is I get clients who are like, I gave a statement to the police. I regret some of the things I said in that statement. Should I go give another statement to the police? And I always tell them, no, God, no, don't do it. Meanwhile, if there's a witness against one of my clients, like, let's say my client goes in and robs a bank, and there's only the bank teller in there. It's a small little bank. There's only one teller. Or let's not say bank, because banks have lots of people. Let's say he robs a convenience store, and there's only the cashier at the convenience store. And so this is coming down to, it's a one witness trial, right? If the cashier at the convenience store gives one statement, I'm like, all right, we'll have to see what's in that statement. If that cashier gives 3 statements, 4 statements, I can pretty confidently tell my client, I'm like, this is going to be pretty okay. This is going to be pretty good. And the reason why is because there is no way that cashier gave 3 or 4 exactly identical statements. And if that cashier gave statements that differ even a little bit between those statements, if those statements are not exactly the same, I get to make that cashier look like an idiot on cross-examination. And you might say, Runkle, that's a terrible thing. Why would you make this guy look like an idiot just because he, got things wrong? That's the job of a defense lawyer. And if you can't do that, then you don't want to be a defense lawyer. Like, sometimes your position as a defense lawyer is to poke hole in the prosecution's case. The prosecution has to prove their case beyond a reasonable doubt. My position is to say, is it though? Is it? So, yeah, having that additional statement, having that additional detail, that would have been helpful. I 100% agree with Bowles that having that statement would have been helpful to him, and would have been potentially critical. Even though I don't know that these statements that he identifies themselves are earth-shattering, I'm just like, having another statement is a big deal. So, and like, the best places where they've given inconsistent statements in one statement versus the other, because then no matter what they say, you can make them look like a liar, right? All right. So let's keep going here. Most critically, several of these statements are new and different and would have been critical to cross-examination, including to show Ms. Gutierrez-Reed's experience, that allegations of her being unsafe were not something Mr. Kenney ever heard. He was not on set, by the by. That props and armor needed more support, that if the camera crew or others did not feel safe, they should call the hotline. Most critically, he said he received 325 rounds from Thel Reed, which is important because the ammo could be found in his shop. PDQ was found empty during the search warrant, i.e. they could have pointed the finger at Seth Kenney. Mr. Kenney also represented in the Friday, July 12, 2024 hearing that he brought back 50 to 100 rounds with him to New Mexico and no explanation as to where they went. The state also made repeated points at trial about guns being left unattended. Yet in his previously undisclosed interview, Kenney said that the sheriff confused real and prop guns. Kenney also made conflicting statements on sabotage. This was favorable Giglio information that the state suppressed, and that was material. The failure to produce this statement is a clear violation of the rules of court there. So, now let me just talk about why the sabotage theory is stupid. Let me talk about why it's stupid. So, let's say, for example, let's say that Seth Kenney said to Hannah Gutierrez-Reed, I'm sending you another 100 dummy rounds. You know, Seth Kenney or literally anybody else, but let's assume it's Seth Kenney for this hypothetical, right? Let's say I say, I'm sending you 100 dummy rounds. And then because I'm malicious and I just, you just want to see somebody die. Let's say you then go and sprinkle in like 5 live rounds into that. Here's the thing. The armorer should catch that because the armorer needs to always be considering the possibility that the manufacturer of dummy rounds screwed up and sent them a live one. That is why the armorer checks every round. They check every round to make sure that everything is fine. And they check and they check and they check and they check. And every armorer I was talking to was saying, like, we check the stuff when we get it. They say every round we get, like, and I heard this from multiple armorers talking about their procedures. They say when they buy rounds from the manufacturer who makes the dummy rounds, the first thing they do is they check every single round as it comes into their facility. They check it. And then after having checked every single round before they, like between we've received it and we're putting it into our stock, before when they say, okay, we need 500 dummies for this film set. They pull them out. They check them again. They check them coming out of stock and then into, like, before they get sent out to the production. They check again. On site, they check. And every time they pull a round, they check it. They check and 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 they check because you don't know, right? You just don't know. And you have to assume that at some point along the line, somebody could put something in. Let me just give you an example of how something could get in. How something could get into, how live rounds could get in. This is actually an example from, I think it was from Dutch Merrick. There's another channel that did an interview with a bunch of armorers. I don't recommend it because I don't think that they really covered themselves in glory. But one of them was talking about how they were filming a military video. They're filming a war video, but they were doing it on a military site with military equipment, like military vehicles. And one of them found a live round of .556 ammunition, which is very similar to 223 ammunition. And so once he found that, he was like, we need to stop everything. We need to recheck our stuff, and we need to make sure we sweep these military things very carefully. There was another example that they gave of a film scene in an alleyway. And when they went and were looking around the alleyway, they found live rounds sitting in the alley. Somebody had left ammunition just in the alleyway because, whatever. So it can happen. If you think about a scene filmed out in the wilderness, right? Like out in, out in somewhere like a western town or just like a piece of desert. It could be that there's a bit of live ammunition out in that desert because somebody was out shooting cans or somebody was out whatever, and it just happens to get ejected as a live round and lost and forgotten. But here's the potential that could happen. The potential that could happen is you've got somebody who wants to be helpful. Some actor or extra or grip craft services, whoever, somebody wants to be helpful. And they reach down, they pick up a thing, and they just put it on the prop cart. They put it on the, and they're like, oh, I found what must be a dummy because they don't know. And they just throw it on the, prop cart. That helpful person might have just introduced live ammunition to your set. Which is why the armorer has to check and check and check and check and check, because you don't know if some helpful idiot just inadvertently sabotaged your film set. You check every single time. What did Hannah say? Hannah said, I don't have to check every single time. Yeah. Yeah. Suppression to the Haag report. So the accident involving the firearm that led to the indictment of Ms. Gutierrez-Reed occurred on October 21st, 2021. The state first charged Ms. Gutierrez-Reed with involuntary manslaughter on January 13th, 2023, and the trial commenced on February 28th, 2024. Ms. Gutierrez-Reed's principal defense theory was that no one had committed a crime and that this was a tragic accident, and that if there was any negligence, it was on the part of the producers, as found by OSHA. This defense would have been immediately bolstered by a legally unforeseeable intervening cause, such as a firearm malfunction that caused Ms. Hutchins' death. The thing is a firearm malfunction, the gun can't malfunction if you didn't put a live round in it. And the other thing is you should expect that guns can go off, right? I don't think that this actually is all that helpful, but okay. This is perhaps the most important evidence in the case of an unforeseeable intervening cause. Indeed, post-trial, one of the jurors called undersigned counsel and said the jury was split and that they ultimately thought the tragedy was foreseeable and there was no intervening cause that broke the chain of causation. In short, the Haag report is critical new evidence. Do you have an affidavit from that juror? Because if you don't have an affidavit from that juror, then that's a problem. Because if you don't have an affidavit from that juror, the only person who can testify about this is you, son. And you can't be the witness and the lawyer on this matter. You should not be arguing this, Mr. Bowles. And you'll see that in the Karen Reed trial, Jackson and Yannetti, who are without question better lawyers than Bowles is, I don't think anybody would argue that point. I don't think anybody would question that issue at all. Certainly Jackson and Yannetti, I hope, would agree that they are the better lawyers. They're not arguing that new issue at all. You can't. You need to put in the affidavit, not. So, yeah. On March 6, 2024, the jury returned a verdict finding Ms. Gutierrez-Reed guilty of involuntary manslaughter. The district court entered judgment on April 18, 2024, when it sentenced Ms. Gutierrez-Reed to the maximum statutory penalty of 18 months imprisonment. That wasn't so much Bowles' fault. That was Hannah's fault. Hannah made that happen. But what neither the court nor the jury nor Ms. Gutierrez-Reed knew was that months before Ms. Gutierrez-Reed's trial, the state's two firearms experts, Lucian C. Haag and Michael G. Haag, issued not just the one report that the state disclosed, but two subsequent reports. Specifically, the results of the Haag's initial examination of the firearm, performed on July 3rd, 2023, were published in a report dated August 2nd, 2023. The results of the Haag's second examination, performed on August 24th, 2023, were published in two separate reports, dated August 26th and August 31st, respectively. The third Haag report found that the firearm contained unexplained tool marks on the working surface and sides of the evidence trigger sear, and that it was unlikely that these tool marks are the result of the damage incurred during the FBI's impact testing, and that the tool marks do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. So, put another way, the state's experts concluded that there were unexplained alterations to the firearm's trigger and sear. I don't know why they said seal. It's a sear. Did he say? Okay, he got sear it right in other places. I think that's just a typo or autocorrect. A critical conclusion that, given that Ms. Gutierrez-Reed's co-defendant, Alexander Baldwin, has claimed that he never pulled the trigger of the gun prior to its firing the bullet that killed Helena Hutchins. So, now I just want to stop and just ask an important question. Who on this set was responsible for the function and appropriate maintenance and care and so forth of the guns? If only there was somebody with the title of, I don't know, armorer? Oh, right, that's Hannah. If the guns are crappy, that's Hannah's fault. Hannah is the one who needs to be checking the guns. Okay, the state, however, did not produce the third Haag report prior to the commencement of Ms. Gutierrez-Reed's trial. I agree that is improper. Instead, the state produced them only to Mr. Baldwin, and only weeks after a jury had convicted and the court had sentenced Ms. Gutierrez-Reed. It was only May 31st, 2024, by which time Ms. Gutierrez-Reed was already at the Western New Mexico Women's Prison in Grants for intake and classification, that Special Prosecutor Morey admitted to Mr. Baldwin's counsel that the state failed to disclose the 831 supplemental report for almost 9 months, and that such failure was mine. Okay, so May 31st, the entire month of June, and then halfway through July, and he just sits on that? He doesn't put it in his notice of appeal. He doesn't amend his notice of appeal. In fact, he files his notice of appeal May 13th, and there is nothing else until June 27th. He makes a motion for immediate release from detention. So, yeah. And that, yeah. Like, why are you sitting there? Why are you sitting there? Now, he did file something about this on June 27th. June 27th, he filed something about this. A full month after he says that he got it, and the court is like, not so much of a big deal. I'm just like, okay. That is a problem. Why did you sit on this for a month, sir? The timeline of the state's discovery disclosures in Mr. Baldwin's case is important to understand for purposes of this motion. On January 24th, 2024, Mr. Baldwin made his initial discovery demand. Between April 22nd and April 29th, 2024, Mr. Baldwin repeatedly raised concerns to the prosecution about missing expert materials and other missing discovery. Did you do that? Did you do that, sir? Or is it just Mr. Baldwin's lawyers who are absolutely better lawyers than you are? Then on April 29th, 2024, Mr. Baldwin apparently learned of the second Haag report when Lucian Haag referred to it in his pretrial interview. And then it was more than a month later, on May 21st, 2024, that he learned of the third Haag report during the pretrial interview of Michael Haag. Meanwhile, the state was actively prosecuting Ms. Gutierrez-Reed. Her trial began on February 28th, and the jury delivered a verdict on March 6th, and the court imposed sentence on April 18th, 2024. And during Ms. Gutierrez-Reed's trial, her attorney examined Lucian Haag about the precise exculpatory issues raised in the third Haag report. Said, okay, sir, and in your inspection of that weapon, the Baldwin revolver, did you see any modification that would have changed the firing characteristics of that weapon? No, not at all. And to be fair, he says that they didn't change the firing characteristics of that weapon. Okay, sir, so other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage? And he says, I did not. He later concluded, by the way, that those weren't a modification. So, yeah. But he did mention this in a June 27th thing. At the same time that Lucian Haag gave this sworn testimony, the state possessed a report stating the exact opposite, specifically that the firearm contained unexplained tool marks on the working surface and sides of the evidence trigger sear that, one, unlikely are the result of damage incurred during the FBI's impact testing, and two, do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Although Lucian Haag's trial testimony directly concluded or contradicted his conclusions in the third Haag report, the state continued to withhold the third Haag report and its contents. That, I think, is a problem. It's just, why were you sitting on it? With the third Haag report, Ms. Gutierrez-Reed would have had a sufficient evidentiary basis from which to argue that unexplained alterations to the firearm caused it to fire without anyone pulling the trigger. An unforeseeable intervening cause that rendered her conduct not legally responsible for Miss Hutchins' tragic death. Except she's responsible for the function of the guns, and she's responsible for ensuring that no accidents happen, even if the gun fails. I mean, the thing is that, like, how could I have known that this would go off? One of the things is you have to assume, what happens if the actor pulls the trigger when he wasn't supposed to? What happens if the gun goes off when it wasn't supposed to? What happens if, like, all of these things, you actually need to... This is why you check, right? This is why you check. Like, here's the thing. If she says this gun is unloaded, cold gun, it doesn't have blanks in it, it doesn't have, it doesn't have, live rounds, it doesn't have anything, right? What happens if an actor just takes the gun and puts it to his head and pulls the trigger a few times? Well, it shouldn't go off. That's the whole point. You were prepping a gun to be a cold gun, and you instead prepped one with live cartridges. This is... None of this actually should functionally help him. But yeah. Nor was she able to impeach Mr. Haag's testimony with his prior inconsistent statements. I agree he should have had that right. A few weeks after that testimony, the jury convicted Ms. Gutierrez-Reed of involuntary manslaughter. It might have also helped if you brought an expert who wasn't a complete clown, because that expert was, in fact, a complete clown. Yeah, I mean, his expert was so bad. So bad. So, yeah, we'll have to pull that up at some point just to show just how bad, because so bad. All right, let's keep going. Suppression of additional material. This week, the Gutierrez-Reed defense has also become aware of another possible 900 or so pages of material related to state's witnesses Brian Carpenter and Haag that was not disclosed to undersigned counsel. Okay, that's a lot. This material was disclosed to counsel for Mr. Baldwin shortly before his trial. It appears that this material consisted of email communications between the state and those witnesses that were not disclosed by Ms. Morrissey. Counsel are still reviewing these at the time of filing this motion and may supplement with exhibits in a reply. Fair enough, right? They got to get this in real fast. And I see somebody saying is that they're having trouble sending super chats. I don't know why. If you're having trouble sending super chats, my email address is runkleofthebailey. Let me see if I can edit the description here. So I'm putting my PayPal email address into the description if you're having trouble sending super chats. That said, I don't usually see... I can't change the description because it's now. I'll have to go onto YouTube. It's runkleofthebailey@gmail.com. I will just put that in the chat, I guess. So that is a way to send something via PayPal if you want to contribute, but I don't usually see them midstream, so I usually can't read them out. All right, I got to figure out a way to make that happen. So, all right, so they may supplement this with exhibits in a reply. Fair enough. It is too important for Ms. Gutierrez-Reed to have her motion filed immediately, given the July 12, 2024 hearing and findings. Fair enough. Your client's in jail. Fair enough. You want to get that in as soon as you can. As just one example, attached as Exhibit E are numerous emails, approximately 36 pages, involving Brian Carpenter and state prosecutors. Now, I don't know where that exhibit is because it doesn't appear to actually be attached to this. I just don't see that we have those because this is 35 pages long. So where are those exhibits? Where are my exhibits at? I don't see we don't seem to actually be getting those. So yeah. Where's that at? All right. So in one dated January 18th, 2023, between the state prosecutors and Brian Carpenter, related to the drafting of Mr. Baldwin's probable cause statement, in that email, Mr. Carpenter says in part, "Team, first off, excellent job, Robert. Very compelling document and well written. I have redlined anything I found notable." In another, towards the end, he appears to email additional thoughts regarding Ms. Gutierrez-Reed's probable cause statement. As this court may recall, Brian Carpenter was the state's expert witness in the Gutierrez-Reed trial as well. This email is one that counsel has located in cursory search, demonstrating the expert's bias towards the prosecution and the fact that he's involved in helping draft a probable cause statement supporting charges. You know what? Fair enough. I would absolutely argue that. Good for Bowles. In yet another, he states that Sarah Zachary knew nothing or next to nothing about firearms. I mean, of course they wouldn't be mentioned. So, yeah. Or of course she wouldn't know guns. He goes on to state that her hiring was for low budget reasons, and the only thing to mitigate that was to hire an experienced armorer, but that didn't happen again, more likely for low budget reasons, again blaming production. In another email dated November 17th, 2022, Carpenter writes to prosecutors that he's talked to one of the top 3 prop house owners in the U.S. and a very well-known prop master, and both of them, without hesitation, felt a major amount of responsibility fell on the prop master. He goes on to believe Hannah is very accurate in saying in her statement that they, production, were jumping her ass for not working hard on props, and that they wanted more done in the props area to save money. He states that Gabrielle Pickle was one from production who stonewall all the training and armor a day requests. He references people believing Gabrielle Pickle and members of the production being responsible. He notes further blame on production in bringing the props master and armorer in late, not giving them a props truck, and having locations working out of the same truck as being completely wrong and the fault of production. These were all themes that Ms. Gutierrez-Reed espoused at trial, and she never had access to these statements to cross-examine the government's expert, Carpenter. I agree they should have had access to it. I agree. In another email on February 6, 2023, Carpenter states that he's reviewing something that appears to reflect a total of 86 live rounds, which is a big thing as they were scattered throughout and found at PDQ. This is Seth Kenney's business, and the number of live rounds found at his business was a source of major contention at trial. Again, the armorer should have caught it, even if Seth Kenney intentionally, and I'm not saying he did, but even if he intentionally sent live rounds in, that Hannah should have caught it, right? Like, even if that was intentionally done, she should have caught it. That's why you check the rounds. Again, these are all statements required to be disclosed. Oh, hey, Court TV, good to see you. Under 5501. The repeated discovery failures are certainly beneath what Ms. Gutierrez-Reed deserved. I agree with that. How long was her sentence? 18 months. 18 months. And for her, the impact has been devastating. She now sits in prison serving an 18-month sentence based on what we now know was a proceeding that was rendered unfair and unconstitutional by the state's conduct. This court should not countenance the state's deplorable behavior. Okay. So the state violates the defendant's due process rights when it suppresses evidence favorable to an accused upon request where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. So evidence qualifies as material when there's any reasonable likelihood that it could have affected the judgment of the jury. And I agree this is material. I agree that it is material. To prevail on her Brady claim, the defendant need not show that she more likely than not would have been acquitted had the new evidence been admitted. She must only show that the new evidence is sufficient to undermine confidence in the verdict. I think we're there. Thing is, I still would have said that she should have been convicted if it was me as the bench trial, like in a bench trial. But that's why you put it to a jury. You don't want me as your judge on this one. So, in particular, the state must disclose any statement made by any witness whom the prosecutor intends to call at the trial that is within the knowledge of the prosecutor. When a defendant has been found guilty, the court on motion of the defendant or on its own motion may grant a new trial if required in the interests of justice. A motion for a new trial based on newly discovered evidence is appropriate where that evidence will probably change the result if a new trial is granted and was discovered after the trial, and could not have been discovered before the trial by the exercise of due diligence. I agree that that's the case. How do you find out that a statement was made if you didn't know that it was made? How do you find out that it was made? Is material, is not merely cumulative. Merely cumulative just means like you already had that issue. It just would have been more helpful. And it's not merely impeaching or contradictory. I agree that it's not those things. So I actually think he's got a pretty good case for a new trial. We're going to talk as well about what happens if he gets a new trial. So also, Sonny, Morrissey, like Hannah actually she was offered the same deal. She was offered the same deal that everyone else got. She turned it down. And the reason why she turned it down is that she would never have worked as an armorer again, but she's still never going to work as an armorer again. So, yeah. So the court should order Ms. Gutierrez-Reed to have a new trial or for a dismissal. So prosecutors bear significant responsibility in the administration of the law. It is as much their duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So they note a prosecutor may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. They quote this particular language is quoted everywhere that we see these kinds of issues, because the not at liberty to strike foul ones is just such poetic language that this particular phrase has really ingrained itself into the fabric of American case law. In fact, even in Canada, I am going to start stealing this line. I'm going to start, stealing it. So it is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So the conduct of the state is exactly the evil the court had in mind in Berger and again in Brady and Giglio. So under Brady, the state is required to disclose favorable evidence to the defense upon request. Critically, the U.S. Supreme Court has held that the state violates a defendant's due process rights when it suppresses evidence favorable to an accused upon request, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Moreover, the prosecution for Brady purposes encompasses not only the individual prosecutor handling the case, but extends to the prosecutor's entire office, as well as law enforcement personnel and other arms of the state involved in investigative aspects of the case. There can be no legitimate dispute that the state violated Ms. Gutierrez-Reed's due process rights under Brady, given that it is now stipulated that it failed to disclose evidence that is both favorable to Ms. Gutierrez-Reed and material to her guilt. As to the first factor, the third Haag report is favorable to Ms. Gutierrez-Reed. It corroborates a defense theory that exculpates Ms. Gutierrez-Reed. I don't know that it actually does exculpate her, but I think that a jury could find it exculpatory. I think personally that the defense theories here just actually are entirely consistent with guilt, right? I think that they are entirely like, hey, somebody else sent live ammo. Like, no kidding. But that's her job to catch. That's her job to catch. Oh. Hi, Sophia. It's her job to catch that. The other thing is, if the gun wasn't working, again, she should have prevented that from being an issue. But I still think that this is a key issue in terms of the jury should have been able to make that call. Not Runkle, the jury, right? Because I'm not a juror. So I do think that this actually is a good argument here in this sense. In the sense of the legal argument, it's a good argument. In the sense of the factual argument, I think it's a bad factual argument, if that makes sense. This doesn't convince me that Hannah Gutierrez-Reed is not like at fault, but it does convince me that there is a legal problem here that the court needs to sort out. So, yeah. Hindsight is 2020, though. Shaking my, I mean, here's the thing: hindsight is 2020, but that doesn't mean you can cut safety corners. Cutting safety corners tends to have that hindsight effect of, oh, that was a bad idea after it goes wrong. But the whole fact that it could go wrong is why you don't cut corners on safety. So as to the first factor, the third Haag report is favorable and would have changed jurors' weighing of the evidence in essential ways. Whatever conduct the state alleged against Ms. Gutierrez-Reed, that conduct was not legally responsible for Ms. Hutchins' tragic death, because no one could have foreseen that unexplained alterations to the trigger/seal. He really needed to do like a find replace and eliminate every mention of seals, because there are no seals in this case. Like, would lead to a freak malfunction causing the gun to fire. If the jury had credited this theory, which the state's own expert reports would have corroborated, the jury necessarily would have acquitted. No, they wouldn't have. Necessarily would have acquitted, I think, is way too far, because the jury could have been like, oh, who was responsible for the guns? Oh, that's Hannah. And also, even if Baldwin intentionally pulled the trigger, that's still Hannah's fault. You know, it would also be Baldwin's fault. It would also, like, Baldwin would also have fault. Many people would have fault. But like, Hannah would be liable for the live round. I don't think that this gets us to a jury necessarily would have acquitted. That's too far. But a jury might have acquitted her. So the defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death, and without which the death would not have occurred. I don't know that that's that's an interruption, but he's entitled to make the argument. That's the thing. But Ms. Gutierrez-Reed was not able to pursue that theory because the state buried evidence in its possession that was necessary for her to make that case to the jury. Nor did Ms. Gutierrez-Reed fail to ask the right question. She specifically and repeatedly, that the state produce all evidence subject to Brady and Giglio, and then at trial, even without knowing that Lucian Haag had opined in writing in the third Haag report that there were modifications or damage other than what resulted from the FBI testing, they asked that specific question. And then they quote the same thing that we read over again. The fact that Ms. Gutierrez-Reed asked the question and Lucian Haag perjured himself in response, I don't think he perjured himself, because he did say, like, I don't think that he perjured himself, because he said, I did later examination and I figured that it wasn't actually a modification after the fact. The problem is that he changed his mind after that third report. So that's not perjury. That's just inconsistent testimony or inconsistency. But he's got an explanation for that inconsistency. I think perjury is too far. In response, should dispel any suggestion that the truth memorialized in the third Haag report would have been exculpatory as to Ms. Gutierrez-Reed. I don't think that this is perjury, but I think that this is absolutely something that the prosecution would need to get ahead of. Lucian Haag's perjury, again, I don't think it's perjury, likewise supports the second factor that the third Haag report was material to Ms. Gutierrez-Reed's case. Evidence qualifies as material when there's any reasonable likelihood that it could have affected the judgment of the jury. To prevail on her Brady claim, Ms. Gutierrez-Reed need not show that she, more likely than not, would have been acquitted had the new evidence been admitted. She must only show that the new evidence is sufficient to undermine confidence in the verdict. So, and the defendant can prevail even if the undisclosed information may not have affected the jury's verdict. And this is the point I've been making. I think that he's got a great legal argument here, even though I don't think it would have, affected the jury's verdict. I still think it needed to go to the jury to make that call. The facts of this case far surpass that low threshold. The state's entire theory of guilt was that Ms. Gutierrez-Reed's criminal negligence in mishandling the gun caused the death of Elena Hutchins, and that her death was a foreseeable consequence of Ms. Gutierrez-Reed's negligence. Ms. Gutierrez-Reed's trial strategy was built on the assumption that there was no evidence suggesting the gun may have been modified or damaged at the time the incident occurred. Whose job was that? Had the state disclosed the third Haag report, Ms. Gutierrez-Reed could have used its content to sow reasonable doubt as to causation generally and foreseeability. Ms. Gutierrez-Reed never got the opportunity. The thing is that her negligence in mishandling the gun would still have caused the death of Elena Hutchins, even if the gun was defective, right? The fact that Lucian Haag perjured himself about this very subject when he testified at Ms. Gutierrez-Reed's trial, and that the state continued to dissemble about the third Haag report for months when Mr. Baldwin continued to press, only underscores how important the state views this evidence. I don't know that we get there, but okay. There's no conceivable reason to lie and deceive about something that doesn't matter, except that they actually said, yeah, there was a third report. We were supposed to get it to you and we screwed up. I don't know about this goes a bit too far for me, but whatever. It doesn't much matter here. Whatever the state's intentions, there is no dispute that it failed to disclose the third Haag report until after Ms. Gutierrez-Reed's conviction and sentencing. And that is all that matters. Whether this suppression was inadvertent or intentional does not affect the Brady analysis. Correct. There we go. That is important. The state's failure to disclose the third Haag report to Ms. Gutierrez-Reed until months after her trial constitutes a violation of her due process rights under Brady that warrants a new trial. While the violation of Ms. Gutierrez-Reed's rights under the U.S. Constitution is sufficient to vacate her conviction and order a new trial, her rights under the New Mexico Constitution are even more expansive. Under New Mexico law, she's entitled to a new trial because they violated its duty to disclose evidence that was material and thereby prejudiced Ms. Gutierrez-Reed. So first, they had a duty to disclose under New Mexico law because it's a document that's within their possession, custody, or control of the state, and which is material to the preparation of the defense. and any statement made by a witness that is within the knowledge of the prosecutor, and any material evidence favorable to the defense. So they have an even stronger obligation to disclose, right? So the rules create disclosure obligations beyond those required by the Due Process Clause. Here, the state was obligated to disclose the third Haag report thrice. I agree that they were obligated, so we'll move on a little bit. Second, the report was material. I think we've already agreed that I think it was material, even though I think it was material, I don't think it would have. Well, I don't think it changes my impression, but that doesn't mean it wouldn't have changed the impression of a jury. So I agree it's material. We'll skip past this because it's getting a bit repetitive. And third, that it was prejudicial. They note that one way of finding that the prosecutor's failure to disclose evidence prejudiced the defendant is, had counsel been aware of the undisclosed evidence, he may have altered his strategy. I agree that that's made out here. Absolutely could have made it out for. What do people not understand? That if it takes 15 hours to do a job, you got 10 hours paid to do. You can't complete the job unless you either work for free or get more hours. Why is it hard to understand? Thing is, the armorer's job is to take the guns and walk. If she can't do it safely, her job is to walk. And if she didn't walk, then that's on her. So here for trial strategy, they say, had Ms. Gutierrez-Reed's counsel been aware of the third Haag report, he undoubtedly would have modified his trial strategy to attempt to introduce a reasonable doubt. Bowles. You dumbass. You don't attempt to introduce a reasonable doubt into the minds of the jurors. The prosecution has to prove beyond a reasonable doubt. I hate your language here because reasonable doubt exists before you get there. You don't have to create reasonable doubt. It has to be, I would have put this as it is, it would have been impossible for the prosecution to prove beyond a reasonable doubt the gun's functionality at the time of the incident. I hate when lawyers get this wrong, because you don't, as the defense lawyer, have to create reasonable doubt. Reasonable doubt exists before you get there. The starting point is reasonable doubt. Before the first word is uttered in a trial, you have reasonable doubt. You don't have to manufacture it. There is no obligation on the defense to establish reasonable doubt. It just exists before you get there, and the prosecution must stomp it out. So I don't like the language. Idea: PayPal donations tough to read live. Some streamers use apps reply function instead. Once per month, they go through PayPal's and send short thank you messages. I will have to do that. That is I like that idea, Maisie. All right. So at a minimum, they would have been able to use this to impeach his contradictory trial testimony, and that he can't do so. So, new trial. In the alternative, the court should grant release pending appeal. So basically, listen, even if you're not going to order a new trial right now, we've got a good enough appeal that you should let her out right now. And I think that this is a good point, right? This is a good issue. So a defendant convicted of a nonviolent offense is entitled to release on bail pending appeal if the court finds, one, by a clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. This part is going to be a problem. Because what is Hannah accused of doing immediately? Like, Hannah's accused of smuggling a gun into a bar. And that suggests that maybe she is a danger to the community if released, right? Because smuggling a gun into a bar, not so good. And, there's various suggestions that she violated her bail while she was out. That was all captured on her jail calls. So, yeah. And two, that the appeal is not for the purpose of delay and raises a substantial question of law or fact likely to result in a reversal or an order for a new trial. I.e., you're not just appealing because you don't want to go to jail yet, right? You have to be saying, okay, well, this has to be a real issue. Involuntary manslaughter is not enumerated as a violent crime for the purpose of the statute, and it shouldn't be, because involuntary manslaughter isn't intentional. Moreover, such release is automatic and mandatory upon a finding that the above prerequisites are satisfied. The first prerequisite is going to be your big problem here. For the reasons discussed above, the first prong is satisfied. What reasons discussed above? The first prong is that you're not going to flee or pose a danger to the safety of any other person or the community. How is that satisfied? Like, you've said it's satisfied. Where are your arguments that she's not going to flee? Where are your arguments that she's not a danger? You need to actually argue this, not just tell us that it's not just declare victory on those points, sir. For the purpose of the second prong, all that is required is that Ms. Gutierrez-Reed's appeal raises a question of more substance than would be necessary to a finding that it was not frivolous, and which, if it were resolved in her favor on appeal, would entitle her to a new trial. I agree that that's met, but how do you get to she's not a danger? You got to argue that. You got to say, here's how we know she's not going to flee. Here's how we know she's not going to, okay. So that's that. Now, there are some exhibits. There are not 35 pages of exhibits, but there are some. So Exhibit E from Brian Carpenter to Mary Carmack Altwies, so the prosecution at the time. It says, okay, this is definitely a little extensive, but I wanted to be thorough when it comes to her. I approached the questioning in a slightly confrontational manner. So the questions are formulated as such and set to a particular rhythm. I listed out the questions based on my knowledge of what should occur and relied additionally on information provided. The questions are randomly set with intention and sometimes repeated in a different format. I hope this gives you what you need and maybe some extra. Of course, you guys will know what to throw away, maybe a lot, and what you need to keep, and by no means the layout and content, anything but a suggestion. If it's wrong in tone or subject, just let me know. At least you should be able to a la carte it. I look forward to going over this verbally. Signed, B. Just the B. I missed the dig at Morrissey at the end of the concluding statements. Yes, I did. Conclusion. For the foregoing reasons, Ms. Gutierrez-Reed respectfully requests this court order a new trial or dismissal of the case for egregious prosecutorial misconduct. The court should also order Ms. Gutierrez's release. Finally, the court should order, under its inherent power, that Ms. Morrissey be removed as special prosecutor for the misconduct that has been found and the violations committed in Ms. Gutierrez-Reed's case. Of course, they don't argue that at all. It's just put in there as a shot at the end, but they might still get it. If I was Morrissey, I'd probably just be like, you know what? Peace out. But so questions that were offered. How did you get the job on the filming of the movie Rust? Who directly hired you from the production company? What positions were you hired for? Did you read and break down the script before accepting the position as armorer? Were you aware that this is a gun-heavy movie? Did you know Sarah Zachary, prop master, before being hired? Were you aware Sarah Zachary did not have much, if any, gun experience as a prop master? Did you bring any ammunition with you to the set of Rust at any time before principal photography or during principal photography? Did Sarah Zachary bring any ammunition with her in her kit before principal photography? What did production provide the truck for props to work out of? Who had access to the safe on the makeshift props truck? Was Rust a union show? Did you have a deal memo contract? So Sarah knew Kenney personally. Kenney placed Sarah on his ATF license in order to handle weapons and rent equipment to make money. Sarah admittedly has never even fired a weapon. Production, according to statements made, did not care to properly address safety matters. This leaves you as the armorer to oversee the entirety of safety on set of all firearm-related matters while you were also working in props as an assistant. Do you see where I'm going here? Tell me why this situation was allowed to develop initially and then further compound itself until the fatal incident. So the following questions and observations are specifically from her interview. So page 8 of the transcript says that her and Sarah helped get the guns out on set. We're going to skip over most of this after this, but that would mean Sarah touched the guns that day. She also says Sarah helped her with guns during filming. You know what I'm arguing if I see this as a defense lawyer? What I'm arguing is that Mr. Carpenter has stepped out. I would argue that he stepped out of the role of expert and has stepped into the role of prosecutor, and that thereby he has traded his objectivity and has taken on a biased position. And so that is a big argument that you'd make here. And they go on to basically show all of the arguments that, all of these questions that he suggests. So the argument here is that Brian Carpenter was no longer objective. He's on the prosecution team and thereby is not just presenting information that'll be helpful to the court, but is now presenting information to help secure a conviction. Somebody says, is he a cop? No, he's not a cop. He's a film armorer. This absolutely should have been disclosed to the defense. This should have been provided to the defense, in my view. So another email from Brian Carpenter. One more point that might avoid any delays or stalling on those contracts and company information. In order to receive their tax incentive monies, the state film office needs to review and approve the project. In MS, you receive a tax certificate after approvals with earmarked funds. New Mexico's process, I'm sure, is very similar as most states are. Having said that, they will have on file a great deal of pertinent information regarding contracts, funding, etc. It's worth a call and may save some time. I.e., here's another way you can get the contracts. If you need me to call and inquire to their requirements, I will, as I speak the lingo, or I can provide additional information if needed. Just let me know if you do. So, yep, and there's some other stuff that is quoted here. Just going to see if there's anything critical. He helps them explain some of the call sheets and so forth. That is fine. I don't see any problem with him explaining the call sheets. And what they need. All right, another email from Brian Carpenter. First pass of most concern was the need to coalesce the armorer, actor, producer responsibilities, as there's a definite overlap that I feel will help us greatly. He's putting himself on the team. That's not good, right? So here's the note on the red line in case it does not show on your device. He's giving arguments as to trial strategy. I don't think he should be doing that, but okay. This is a weird redaction. They appear to have redacted one address, but they left his phone number. Okay. So just a quick Cliff's Notes, more from him. So she only worked one other official armorer job the old way and apparently was fired or told to leave. She was elusive during the interview concerning this, following up. She's been doing PA work, production assistant, since PA is basically a runner or do anything assistant, from getting coffee to handing out call sheets. Okay, so a lot of emails. We're just not going to go through the emails in full details, but I don't see anything in this email that is super toxic. But then there's another one. Brian Carpenter. This is something I absolutely would have cross-examined on. Starts with team. First off, excellent job, Robert. Very compelling document and well written. You aren't on the team. You are not part of the team. You are not team. Yeah. So that's a problem. Email from Carrie Morrissey to Jason Bowles saying, Jason, I've decided not to have them tested or picked up, referring to the Teskey rounds. These are clearly dissimilar to the live rounds found on the set due to primer and projectile characteristics. If you want to have them tested, feel free. It's not our responsibility. You can test them. That's on you. I can't see how it's relevant given that they're clearly dissimilar, but keep me posted if you want to have them tested. If you can't get that done within the next couple of weeks, you may need to continue the trial if you intend to use them. Since, just signed Carrie. I disagree with his notion that only the FBI could test them. It might have been convenient to have the FBI test them, but I don't see any obligation that the FBI had to be the one to test them. So, and if he said, here's why I need the FBI to do it, I don't see why he wouldn't have said that in this. So, yeah. So what do I think happens? I actually think this is probably good enough to get the new trial. I think that they're at the new trial stage. I'm not guaranteeing that. I say 75% to new trial. And part of that is that we already know the judge is pissed at Carrie Morrissey. And we know which judge is going to hear this. It's the same judge that's pissed off at Morrissey because of the disclosure violations on Baldwin. So that's great for Bowles. I think he's got about a 75% chance of getting the new trial. And somebody says chain of custody. Yeah. You hire a private investigator to pick them up. You have that private investigator move them specifically over to that. And you do that. Shifting the burden of proof. It's not a shifting the burden of proof because the defense can absolutely just argue the prosecution should have tested them. Why didn't you test this? Why didn't you look at it? Bring those bullets in. We want the jury to see them. And why did you not test them? Why didn't you determine if they match? Right? They do that. What if she gets an even longer sentence? She can't. She can't get a longer sentence because, quite frankly, the maximum sentence is 18 months. And the only way she could get a longer sentence is if the judge said the maximum sentence is 18 months and we're not giving her any credit for the actual jail time. And I don't see that happening. I just don't see how that could happen. So I don't see it. So yeah. Now, what happens if he wins here, if he gets a new trial? Well, new trial where all of this can be argued. But Hannah would have a really big problem on a new trial. And the big problem she has on a new trial is she made further stupid statements. All of her jail calls were recorded. And all of her jail calls being recorded means that they can be brought in at a new trial. At least the ones that are relevant to her actions on the Rust set. And there's one statement she made in particular that will absolutely be a problem for her on a new trial. And that statement was something along the lines of, I'm paraphrasing here. I don't have to check every round every time. What? Yes, that is absolutely your job, to check every round every time. That is absolutely the job. And that evidence would absolutely be tendered at her new trial. I I see all her jailhouse statements to other inmates. There are probably, the thing is, there's probably inmates willing to say she made stupid statements. I wouldn't even use them at the new trial. Like, I wouldn't even rely on anything she said to other inmates, because other inmates might not be the best witnesses. But like, it's a big issue. It's a big issue. Let's just, I'm just going to quickly pull this up. Yeah, we're just going to quickly pull up this. We're going to see about sharing it. We're going to, here we go. All right. So this is the state's response to the sentencing. State's response to the sentencing. So, yeah. What do we have here? These bits about her liking it in jail aren't going to be a big issue, right? However, Hannah says that she can't believe that the judge put her in jail. Hannah talks about how the jury and how they only took 2 effing hours and how she got the book thrown at her. She says that everyone lied on the stand except for 2 or 3 experts. Everyone lied on the stand except for 2 or 3 experts is like, oh, okay. So she agrees that several of the experts told the truth. She talks about the witnesses and how they all lied. She says that she didn't need to be shaking the dummies all the time. That statement, absolutely, they're going to put in there. That they will absolutely throw in there. Let's see what else here. They might talk about things like, goes to her hotel room to clean up. That's not great. What else do we have? Her detail about how she won't show up if she's subpoenaed. That's not great either, because if she wants to testify, and Rob Smith saying, sorry, I can't super chat. My credit card was defrauded. No worries. Like, there's no obligation to super chat. It's helpful. It supports the channel, but there's no obligation. I don't want people to feel that they have to, right? So, let's see what else. I mean, the details about her enjoying jail isn't going to be a big deal there. Those aren't the huge thing. Calling Carrie the B word isn't going to matter. Jason Bowles needs to talk to Roger to get everything out. She's got a PR person that I might cross-examine her on. Did you hire a PR person? Were you planning on writing a book? Maybe not so much, not so super relevant. Blame the child on set for being dangerous on set. That I would absolutely bring in if I was the prosecutor. Hannah talks about the kid getting the gun that was just laying on the ground. I would absolutely go into if I was the prosecutor. So I would absolutely go into that. Let's see. Anything else in here? Yeah. Talks about how she shouldn't be a felon. Maybe they can get it knocked down to a misdemeanor. So she doesn't want to bother the governor for the rest of her life so she can be pardoned. You're not going to be top of the list for pardons. System failed her. Hannah says that she won't have anyone to smoke weed with and that she's going to smoke weed when she gets out. Oh, so you're a drug user. You smoke marijuana. Is that a good idea to smoke marijuana while you're an armorer? Were you doing that? So all of these things are things that she might be forced to ask, to face if she is, if she faces a new trial. So we'll see. We'll see. I think that maybe she gets a new trial. I think maybe she gets a new trial. Maybe she looks at a plea deal. Now, I see some people saying, would Carrie Morrissey prosecute this? If I'm Carrie Morrissey, I just say, you know what? I don't want to prosecute this one. Get a new special prosecutor. You need somebody who isn't me. I think that a special prosecutor needs to, that they need a new one. Abyssoft says, would a new trial be quicker than serving the sentence? I think she's still got like a year on that sentence. So the goal they want her to be released pending that new sentence, right? So that she's not actually in jail that whole time. So hopefully it takes a while out, and she's hoping she's released during the intervening time. Lol, weed is not drugs. Here's the thing. Where is it? Where is something here? I don't smoke weed often, but I do smoke weed occasionally because it's legal in Canada. I will tell you, I don't smoke weed if I'm going to go to a trial. I will not consume marijuana if I've got a trial. I don't consume marijuana and drive. I don't consume marijuana and handle firearms. I've had people say, come on out to the range. Let's do a thing. And I'm like, yeah, that's okay. I had an edible. I'm not going. So, there is no way that I would be a film armorer or anything like that. If I was, if I had weed in my system. And yes, weed is a drug. And so, for that matter, is caffeine. Now, caffeine isn't a drug that causes impairment. Some drugs will impair you, some won't. Tylenol is a drug, but it doesn't impair your function for that kind of thing. But weed is absolutely a drug, and it absolutely is a drug that can cause impairment. So, yeah. I know someone that went to prison. He said illegal drugs were easier to get in prison than pot. Why would you smuggle pot into prison if you can smuggle fentanyl into prison? And the other thing is that people don't want to use weed in prison because weed has a smell to it. You don't want to smoke weed in prison because you're going to get caught, right? You're going to get found. So people use stuff that is less obvious. So, all right, let's go through some super chats here. I think anyone who's had a coworker that was super dependent on caffeine might argue. I mean, I absolutely use caffeine to manage my attention deficit. So, because Fralkin, super chat seems not to be working. I've seen that a lot. YouTube is just doing the YouTube things. They're doing what they're doing. DSN, thank you for the gifted membership. Much appreciated. And thank you for the super sticker. Ella, thank you for the 5 gifted memberships. Much appreciated. Silly Sailor, why does Baldwin get dismissed with prejudice, but Reed is only asking for a retrial? I think Baldwin's issues were more critical. And also, Baldwin was mid-trial. So, will there be a motion from Hall, or is he out of luck by pleading? He's out of luck by pleading. He's stuck. Also, I don't think Hall cares that much. So, Meg D, thank you for the YouTube membership. Oh, and hard drugs being easier to get inside than outside. Absolutely. Because you've got a target market. You got a target market. Meg D, thank you for the new membership. Much appreciated. Dragon Star, thank you for the 10 gifted memberships. Much appreciated. AK, here's a super chat. I like your videos. Thank you so much. Meg D, thank you for the gifted membership. Much appreciated. Dragon Star, thank you so much. Much appreciated. Jackie Lindy, does this motion mean Hannah can argue ineffective counsel? The problem is she's not going to argue ineffective assistance of counsel because she's going to stick with Bowles because Bowles is doing this for free. He said basically he's doing this pro bono. Good for him. Good for him on that. But so that is an issue there. Tough Cookie, thank you for the 5 gifted memberships. Much appreciated. Marvin CZ, telling the court how to feel about something is like a laugh track. This took many attempts to send. I don't know what's going on with YouTube and Super Chats today. Not the best day to be running live streams, but it is what it is. Tomorrow we'll probably do live streams as well. We'll probably do the Karen Reed stuff tomorrow. Michelle Cox, thank you for the new YouTube membership. Much appreciated. Mark, I haven't slept well in weeks because I have vivid and nonstop mundane dreams about work and stuff. I would not trade dreams with you. That sucks. The alarm dream is my least favorite dream because it wakes you up and you're just like, really? I woke up for that? That wasn't even interesting. Chelsea Rama, thank you for the gifted membership. Much appreciated. It's Bree. I'm a 24-year-old, a vet tech. We double check meds every single time. Double checking keeps pets safe. I've caught helpful people mixing up meds with deadly reactions. Because it's my job as the tech. No excuses for age. Yep. If you're too young to do the job, don't do the job. Don't do the job. Jessica Carlson, thanks for going live in the afternoon today. Thank you so much. We'll probably do it again in the evening. I'm going to schedule one in the evening. Just because, I'm sorry, but this really feels like Bowles waited for Baldwin's team to do all the work for him, and then he wrote this out. I mean, you're not wrong. Bowles probably could have found all of this beforehand, but it's not wrong for him to use Baldwin's team's work. He should have done a better job himself, but fair enough. Young Black Economist, Runkle Squirrel, Runkle Squirrel, Runkle Squirrel. Thank you so much. Wetfoot1313, thank you for the membership. Much appreciated. And Nicole W., off-topic question, but I'm wondering if you gave an opinion on Erlinda Johnson withdrawing from the Baldwin case and her post-trial interview. I haven't gone over her post-trial interview. Maybe we'll do that in the evening. Maybe we'll do that. Maybe we'll add that to the evening coverage. I have no problems with Erlinda Johnson withdrawing. It was an ethical move, and I give her straight points. I give her straight points for making an ethical stand. Absolutely. The other thing is that, and I do have a Patreon. If you search, I have a Patreon. Yep. I have a Patreon, and I also have a PayPal. So I don't have any problem with Erlinda Johnson withdrawing. It is an ethical move. It's a wonderful move. Good for her. That said, if the matter had just been dismissed without further evidence being called, we wouldn't know how bad it was. We would just see, it would look like it was just like, oh, well, is this a big deal? So, yeah. Is it perjury? Carrie lied about it. I don't know that I can get to perjury because perjury's hard to prove. I think ultimately, I think that there is an issue with respect to, I think that they probably had a different interpretation of that conversation, I guess is where we're going on that. Looks like EDB is doing a members only live at 5 p.m. Central Time today. What is 5 p.m. Central in... so 5 p.m. Central in Mountain Time. What is that? So that's 4 o'clock. Okay, that gives me lots of time. I was probably thinking I'll do 6:30 Mountain, which is 8:30 Eastern Time. So it should be lots of time for Emily to finish up her members only so that people can attend both. Because I also kind of want to attend Emily's thing. So I'll probably be in the chat for Emily's thing unless I'm running around running errands, which I also have to do. Mrs. Runkle and I are planning a hiking and camping trip. and I want to make sure everything is all ready to go for that. I want to make sure everything is sparkling. One of the things I got to make sure I do before I do that, just for story time for chat. My car is a little bit more comfortable than Mrs. Runkle's car. I mean, they're both really our cars, but one of them I usually drive. Somebody says, in how many hours is that? 6 hours. 6 hours from now for mine, I think. So my car is the slightly more comfortable, but I am a mess I am a bit of a mess. So I have to clean out my car so that there's A, space for all of our stuff, but B, so that Mrs. Runkle actually has, isn't having to sit in like stuff that I've left in the car. It's not a Volvo. It's a, yeah. Will the dogs be going? No, they won't, because the dogs are not the greatest for that. And some of the places we want to go are not really great places for dogs. One of the places we want to go is to a hot springs. And the thing is I don't want the dogs near the hot springs in case the dogs decide that they want to go and splash in the water, which, could be real bad if it's a hot springs, right? Because hot springs sometimes have waters that, Nikki O'Neill, could Karen Reed's defense team have gotten a not guilty for Hannah? Maybe. K-Rob, anybody knows this case will be thrown out. You don't need this guy to tell you. K-Rob, don't throw shit in my chat. People come here because they want explanations. Like, if you just want the bottom line, you can read my Twitter. But please don't throw crap in my chat or you'll be out of my chat. Somebody says Hot Springs equals Rockies. I think I've probably given out enough information about where I'm going as to, I don't necessarily want to make where I'm going to be super public. Some other people in the chat. What is it with the waters in hot springs? The water in hot springs is that the thing about them is that they are hot. By definition, they're hot springs. Hot springs are, volcanic springs. And so sometimes usually they can be really, really hot. People will go to hot springs to swim, but they'll swim where the hot part of the hot springs mixes with cooler water, right? And if you go into the actual hot part of the hot springs, it is often hot enough to boil the skin off of you. So I don't want the dogs to go and run into the hot springs. So the dogs are going to be in the kennel, right? We're just not doing that. I cannot express how sad that would make me. So yeah. There's some other people who wanted a story about something I mentioned on Twitter. So I mentioned on Twitter that one of the things was that a particular entity from my Project Monolith stuff was inspired by a date that I went on in my earlier years, and that it wasn't a good date. So some people wanted to know about that. Now, I'm just going to note that was long before I met Mrs. Runkle, ages before I met Mrs. Runkle. But I was, I was sort of invited over to go and basically play board games and watch a movie and nerd stuff, right? Nerd things. And so I went over there and she collected little figurines of cats. And she had like hundreds of these things on all of her shelves. And it was creepy. It was just creepy. Now, the person herself was a lovely person. I'm not throwing shade at her. And if she's watching this out there, she's a lovely person. I hope she's happy. It was a little off-putting, and it made me go a little like, I gotta get out here. I gotta flee. So, yeah, that was the moment. Like, just like looking around, I'm going, there are way too many, like, figurines here. So, yeah, I was just like, I got to go. Can I explain Stinchcomb for a Canadian in light of the Baldwin trial? How is it applied? Does a person have to file a motion? So Stinchcomb is a case that basically says the prosecution has a requirement to provide all relevant evidence. And the standard is relevance, right? That is where it's, is. Now, usually the prosecution just provides that material on their own. So every time I run a case, they provide me a package of material, right? They provide me a package of disclosure material. Now, let's say I think there's something that's missing from it. I will then send a follow-up letter going, hey, I want this additional information. And usually they may provide it, or they may say, we're not providing it for whatever reason. The reasons might be it doesn't exist. So in one case, I sent a request going, can I get any video footage that you guys have? Like, do you guys have body-worn cams? Do you have anything like that? And what I got was, we don't have any video footage, so we can't send you any video footage. Okay, cool. Sometimes they'll say, listen, this exists, but we don't think you have a right to get it. We don't think you get it. So, yeah. Fair enough. That's their opinion. The next thing I will do at that point is I will turn around and say, I think I should get it. And I can bring a hearing to force the prosecution to get it. So, for example, in one case, the prosecution disclosed to me a redacted report. And so what it was this police officer had been disciplined at some point, and the prosecution disclosed that he had been disciplined, but they redacted out the details of what he had been disciplined for. And they said, we don't consider that to be relevant to this case. And I went and I brought a Stinchcomb application saying, I want this unredacted. I need to know what this officer did, because this officer is key to this case. And I need to know what his issue was. Like, what was he disciplined for? And the prosecution said, okay, well, we'll fight you. We will challenge you in court on this. We went into court, and the prosecution was made to hand the document unredacted up to the judge. And the judge just looked at it and said, prosecution, what are you doing? I'm obviously giving this to the defense. And so I got it. I got the document. Can you guess what the officer was disciplined for? Can you guess what what that officer was disciplined for? If you said dishonesty, bing, that is correct. So obviously I'm going to cross-examine this officer on his discipline for dishonesty. And the prosecution, after I got that document, after the court required them to hand it over, they did not proceed further with that prosecution. They decided that they didn't have a case anymore. And can you imagine, like, you're saying that you don't think that this document is relevant, right? This document is irrelevant. There's no reason for, I don't work in the States. It's a Crown prosecutor. Crown prosecutor is the term. I just say prosecutor so that people understand, because if I just say Crown, people don't know what I'm talking about. So it's a Crown prosecutor. It was here in Canada. They were saying that this document is irrelevant, but it was so irrelevant that they thought that they couldn't proceed once that information was presented to me. Like, if you don't think that your case can go forward if I get the evidence, then the evidence is obviously relevant. Obviously relevant. Was the Crown prosecutor disciplined by the bar? No. I actually like that prosecutor. I actually like the prosecutor. And I just think that the prosecutor screwed up. I think that they made an oops. I don't think that that particular prosecutor is a bad person. I think that they just oopsed it. And everybody makes mistakes. If the prosecutor, continues to be better afterwards, then good to go. I'm just used to hearing the Crown Canadian also. Yeah, I just say prosecutor because it's a Crown prosecutor. And people are like, what is a Crown? Is a Crown prosecutor the same as a prosecutor in the States? Yes, they are. Yes, they are. All right. Looks like there's another super chat here. Nikki O'Neill, could Karen Reid's defense team have gotten a not guilty for Hannah? I don't want to say for sure, but I think they'd have had a much better chance. And yeah. All right. Yeah. Saying it's not relevant, not an oops. Everybody makes mistakes. And I think that I'm willing to forgive this prosecutor because on other cases, that prosecutor has been an absolute stand-up person. Absolute stand-up person. And what I mean by that is that that prosecutor has killed cases in situations where where it's been called for. And yeah, it's they've done things in other cases that convinced me that they're a good person, they're a good prosecutor. If I had the ability to fire that prosecutor, I wouldn't fire them. So yeah. All right, let's roll the outro, and I will run this again. We'll talk about this again in the evening. So if you've already seen it, you're welcome to join in the evening. You are absolutely welcome to join in, but you may find it to be a bit repetitive. So it's up to you. I would, of course, be happy to see you there. So, all right, let's roll the outro, and I'll see you guys later today.